On behalf of the Institute for Innovation and Prosecution, I would like to welcome you all to our virtual panel discussion on sexual assault prosecution, criminal justice reform in the Me Too era. My name is Michelle Mason, and I'm a Policy and Operations Associate at the Institute for Innovation and Prosecution. Before I introduce our moderator and panelists, I want to invite you all to our upcoming virtual panel discussion on public health prosecution, which will be held on October 26th at 12:30 p.m. Eastern. This panel will be a deeper discussion on our latest publication, A New Approach, a prosecutor's guide to advancing a public health response to drug use. Both the link to the panel and the guide will be placed in the chat. Please follow our socials, which our handle is @IIP_JJAY, to stay up to date on all of our upcoming publications and events. I'd also like to take this time to read our land acknowledgement statement, which honors both the land and culture of Indigenous peoples. We want to acknowledge that the IIP and John Jay College are based in New York City, which is Lenape-Hoking, the Lenape homeland. We honor all of the Indigenous nations and their land with great gratitude and acknowledge the genocide and continuous displacement of Indigenous peoples. We also acknowledge the enslaved Africans whose labor built Manhattan during the colonial era and beyond. We acknowledge the harm inflicted upon the Indigenous communities and people of color across the country, which inspires our ongoing work. Additionally, I'd like to take this moment to remind everyone that today's conversation will be explicitly discussing sexual assault and trauma. We encourage you to prioritize tending to your mental health during this panel and taking breaks or leaving the Zoom when necessary. Now it is my pleasure to briefly introduce our panelists, all to save time because I know that we're going to have a rich discussion. For their full bios, please look to the link that will be placed in the chat. First, I am happy to introduce State's Attorney Kim Foxx, who serves as the Cook County State's Attorney in Illinois. Next is Michelle Dempsey, who is a Harold Reuschlein Scholar, Chair and Professor at Villanova University School of Law. Lastly, we're joined by Lara Bazelon, who is a professor at the University of San Francisco School of Law, where she holds the Barnett Chair in Trial Advocacy and directs the Criminal and Racial Justice Law Clinics. Thank you all so much for joining this panel discussion today. And it is now my pleasure to turn it over to today's moderator, Jeannie Suk Gersen. Jeannie is a professor at Harvard Law School and a frequent contributor at The New Yorker. Thank you.
Thank you. Thank you for those introductions, Michelle. Thank you for having us. And I am really, really thrilled to be here to moderate this panel on a topic that is extremely important, has been important to my work and to all of the work of the people on this panel. And this very distinguished panel is really, I can't imagine a better group of people to be able to have this vital discussion. So I will just introduce the topic by saying that it is clear that in the last 50 years, last half century, we have seen what some may consider to be a massive revolution in the legal treatment of sexual assault. On the other hand, we also have many people who think that there has been too little change in intransigent cultural norms and the indifference of law enforcement to these kinds of crimes. From the beginning of the women's movement in the United States, we have seen the US legal feminist movement seize upon criminal prosecution as a way to achieve some of its goals of gender equality. And the tension between the feminist movement and the rights of criminal defendants has always run through the legal reform efforts that we have seen. And in this era, of course, in the recent past, we have the influence, the growth of the Me Too movement and its impact on many aspects of our society, including legal reform and criminal justice. Alongside that, we also have the movement of Black Lives Matter. So when you take all of these things together, what does it mean to take sexual assault seriously in a criminal setting? And how does that work with progressive prosecution, which is also a movement that we have seen and that many people have pinned a lot of hopes on. We also have a panelist here today who's written extensively about restorative justice versus punitive approaches, And I hope that we can get into some of those questions as well. And then finally, there is this emerging gap, and one that I see as a professor, and I think several of the panelists here who are regularly in touch with students are seeing that there is this yawning gap right now between what universities and university age young people are trained to think is sexual assault versus what criminal law may treat as sexual assault. So that opens up the discussion about the future of sexual assault prosecution in the swirl of all of these multi-directional movements and cross currents. And so with that, I will start with the first question to State's Attorney Foxx. So Kim, when looking at a sexual assault case, what are the considerations that prosecutors make when deciding whether or not to prosecute a case?
Well, first, let me say thank you for having me participate in this panel again with such an esteemed group of experts here. It is an honor and a privilege to be here. Let me just, as I answer your question, just piggyback on what you said about this momentous movement over the last couple of decades around the issues of sexual assault. And what I would suggest is that the movement has not been as swift as one would imagine. When I was a younger assistant state's attorney here in the very office that I serve, back in 2008, I was assigned to our sex crimes unit, and there was a training that our office did to prepare assistants for that. And there was a man who was conducting the training about how we looked at sexual assault cases. And, he said at one point, if it's just the victim's word against, the offender, err on the side of believing the defendant, because there's nothing worse than being falsely accused of rape. And I remember as a survivor of sexual assault being aghast, because I could immediately and did immediately feel and know what was worse. And so that was a mere 13 years ago. And as we, as a profession, as prosecutors, are reckoning with how we have handled sexual assault cases in the past, I want to put the context there that we are not as far as we ought to be, and the culture and the pervasiveness of how we've treated survivors in the past is still very present and something that we have to work on. So saying all of that, in this administration, the way we look at it, we start by believing survivors. We start with that, and then trying to make determinations if there's corroborating evidence to prove the case beyond a reasonable doubt. We know sexual assault cases can be inherently difficult to prosecute because they often have no witnesses. And thus, we also look at other evidence such as DNA, hospital records, injuries, phone logs, text messages, emails, photos, body cameras for excited utterance and statements by defendants. Cameras from crime scenes. We try as best we can to utilize whatever evidence is possible to be able to corroborate what we believe what the victim has said has happened. In addition to that, when we get all of that information, we have to ask the question, do the facts meet the legal requirements that will allow us to prosecute? In particular, does this fall within the statute of limitations? We recognize that most outcries don't happen immediately. And so we want to make sure that we're within the legal time limits that are afforded to us. And then importantly, we discuss with the survivor their wishes. Because in some instances, as you alluded to in your opening remarks, they don't want to pursue criminal charges because of the trauma involved, but they want the abuse documented. Or in some instances, there are those who want a restorative justice approach. And as jarring as that might be from those who've participated in the traditional prosecution model, it's something that we want to take into account. And lastly, I would say in all of this, we educate the survivor about the legal process, the sentencing ranges, the judicial system, acknowledging the trauma that often comes from being engaged in it. And again, being an active partner with the survivor in the course of how we pursue these cases.
Thank you. So I will put a question about Me Too to all of you, and you should feel free to answer or or wait till the next question. Basically, as State's Attorney Foxx alluded to, that in general, the public and survivors may have an understanding about the justice system that may be a little bit different from what a prosecutor thinks about when they decide to bring cases. And so the complications of the justice system may be difficult to completely understand about how to try sexual assault cases successfully. So one of the things that occurs to me about the Me Too movement is this question about due process. We keep hearing about due process for the accused. As a society, how do we learn to value due process for the accused consistent with some of the Me Too movement's ideas? And is it possible to value due process while using what might be called a survivor-centered or trauma-informed approach, or believe the victim, always believe, all of those kinds of ideas? How are they reconcilable? Are they in tension? And so I would love to have some of you talk about that.
So I'll just jump in quickly if I can. So I think, an important two words that State's Attorney Foxx mentioned in her office's approach is to start by believing the victim, right? So actually, it's not the prosecutor's primary job to do the investigation, but police should be starting by believing the victim and pursuing an investigation that's consistent with the possibility that she's telling the truth. So do things like interview the victim, get the rape kit tested, right? There's hundreds of thousands of untested rape kits out there. Many of times we're identifying serial offenders when those finally do get tested. So, do go interview the accused, right? Go to the location and seek corroborating evidence with respect to the victim's description of what it looked like and what she saw. And, make sure all of your police and prosecutors are trained on how to do trauma-informed, victim-focused investigations so that you can at least do a decent investigation, right? That's one of the huge problems when it comes to rape and sexual assault. We don't know if we can prosecute our way out of this problem because we've never tried. Police are, by and large, abysmal at investigating the cases, and then they present them to prosecutors' offices who look at the file and think, gosh, I'm going to have a hard time getting a conviction in this case. And then there's a question about what's the responsibility of prosecutors' offices to go back to the police and make sure a proper investigation is done. So I suppose I just want to kind of challenge the framing. It's not really suspects' due process rights versus believing the victim. It's about doing the proper investigation as you would want done with any crime from the start and seeing it through.
So I think it's a great distinction that you just made that I think is really important, that start by believing versus the refrain we sometimes hear, which is believe all survivors or always believe, right? They're two different statements, and it's a very important refinement that you just pointed out. And so, Kim, I would like to put to you the question, how do you balance the idea, at least the Me Too movement sentiment, right, of always believe or believe all survivors versus due process? Is it that it's, as Michelle just said, it's not believe all survivors, it's actually just start by believing? And is that an important distinction to you?
I think it is an important distinction. Listen, and it's not foreign, right? If someone called the police and said, I got robbed, there is an assumption that they got robbed, right? And so starting there and then saying, well, okay, well, tell me what happened and let's work our way to figure out who robbed you. That's not saying believe all robbery victims. It's how we approach other crimes. I think there was a distinction that was made, particularly around sex assault cases, sex abuse cases, I think because of a power dynamic, because I'll just say it, we're talking about women and how we viewed women and their bodies and their role in their victimization. That's just it. Other crimes, if a man is robbed, we start by believing that he was robbed, and then we build a case. And so I don't think that they're irreconcilable. I think it's how we do our jobs as prosecutors, by acknowledging also that we didn't always treat these types of cases in the same way that we treated other cases, that there was an extra barrier, an extra layer of how we looked at this that was largely centered through a very patriarchal lens. Hence, the person who trained me saying, you know, ooh, there's nothing worse than being falsely accused of rape. I don't know what happened to this trainer in his life that he feels that that's where it is. But if we are training our prosecutors to start with the assumption that the defendant, again, is innocent until proven guilty, that the crime that the victim might be perpetrating, a false report, why are we even introducing that? We're introducing the possibility that our victim is somehow committing an offense. That we cannot do. But I think what we're asking is to treat sexual assault cases in victims, survivors, in the same way that we would treat anyone who reported a crime. We start with the basis that, okay, now let's prove it up. It doesn't mean that you don't do your due diligence. Believing survivors or starting with the belief doesn't mean that if the evidence isn't aligned, that you keep plowing forward. It simply doesn't mean that. And so I think we have to make sure we have that distinction, but really stop segregating the way we've treated these cases, the way we treat other cases, because it is not based on the law or evidence. It's been largely based on a patriarchal system that chose not to believe women.
Is incredibly clarifying what both of you have said. And so Lara, let me ask you, you're a defense attorney and an academic. And so how have you seen the idea of either believe, always believe, or the distinct idea that we've just been talking about, start by believing? How have you seen those ideas at play in the adjudication of these cases from the defense attorney's viewpoint?
Right. So I guess I should start by saying that I don't disagree with anything that has been said. And also I want to acknowledge, Jeannie, that you are a thought leader in this field, and I would be nowhere without your scholarship and your insights. That said, I do take the position that believe all women all the time is in tension with due process. I think that those two things are in tension. And I think we've had some very nuanced comments from Michelle and from Kim about the difference between starting by believing and sort of blanket believing. To me, I think where sometimes it seems like victims can be ill-served, in addition to all the ways that have already been pointed out, I think quite poignantly, is that they may enter into an adjudicatory system unprepared for how traumatic it can actually be, because regardless of the orientation of the police and the prosecutor, should the case actually make its way into the courtroom or be adjudicated by some kind of a fact finder, that person is told constitutionally that they must be skeptical. That's how juries are instructed. They are instructed, right, that there is a presumption of innocence. They are instructed not to believe unless there is a certain amount of evidence, which is the highest level proof that we have, which is proof beyond a reasonable doubt. And I think that oftentimes, at least in my research and kind of in my experience, what happens sometimes with people who have survived an assault and come forward with an accusation is that they can feel ill-treated by the system for some of the reasons that have been said, but even if the process gets all the way through to some kind of a trial, just ill-prepared for how much it turns out in some respects they're on trial, and how to some degree, because of the nature of the system, their story is kind of taken away from them and told piecemeal in a very specific way, designed to get at very specific elements, but it may not be sort of the way that they expected or the validation that they expected to receive. Part of that, of course, is cross-examination, which is endemic and inherent and constitutionally part of our system. And part of it is that you don't get to just tell the story the way that you want. It's told for you. It's told for you through the questions you're asked on direct and cross-examination. And then, of course, there's always a distinct possibility in these cases, because they are so hard to prove, that it won't be the result that you want. And finally, I think, and this is where the research is really interesting about alternatives to the adjudicatory process. And I want to stress that those alternatives are very victim-centered. And so it's really about, you can have the traditional process or you can have this alternative, and not forcing anybody into one particular avenue. But people who have gone through a restorative approach, to the extent that that's been studied, tend to have higher satisfaction rates. And why is that? Well, I think part of it is what many, not all victims want, but what many victims want is for the person who hurt them to admit it and to say what they did and acknowledge it and own it and validate what happened. And of course, the adjudicatory system is designed to do exactly the opposite, because any competent defense attorney will tell you that they're not going to instruct their client to do anything of the sort. And in fact, the system is designed to have the other side, in other words, the person who is accused, deny what happened, deny the truth of the allegations, dispute them. And so if you go in this other direction, it may well be, if the harm that you seek to have remedied is really to have acknowledgement of what happened to you by the person who perpetrated the harm, that may be ultimately the best chance of having that happen. So I guess the short answer to my long answer is I do tend to think that quite often the goals and aspirations of Me Too do collide up against the constitutional protections that are the scaffolding of our legal system.
Well, that is really interesting, and I think that we'll be able to hash it out even more in the next series of questions. So so I'm going to turn now to the broad topic of criminal justice reform, within which sexual assault prosecutions sit. So Michelle and Lara, we're in the midst of a criminal justice reform movement that advocates for sometimes decarceration, and in some cases, abolition. I certainly have many students in criminal law who really do hold to these ideals. So both of you are educating the next generation of lawyers who are at the forefront of carrying out this reform movement. How do you see the next generation of lawyers grappling with the reform movement and with the Me Too movement? And how do you grapple with these movements that may be in some ways in tension, may be paradoxical? Are they in fact in tension? And I know we've talked a little bit about tensions already, but this is something in terms of the movements, how they kind of collide or mix together. I would like to get your take.
Yeah, so I'll jump in, and so to some extent, yes, right. If you hold to a abolitionist view that genuinely wants to abolish criminal law, period, then criminalization of sexual assault is in tension with that view. I mean, that's just sort of conceptually, they're by definition in tension with one another. Now, that said, clearly the problem that we have with overcriminalization and mass incarceration is not due to sexual assault and rape being over prosecuted, right? That it's a small percentage of people who are incarcerated compared to the number of cases that are reported. It's a very small percentage that get through the filter of even being taken seriously by the police and moved on to the prosecutors. So it's just, the attrition rate when it comes to sexual assault and rape is tremendous, and the number of offenses that are actually put into the criminal justice system are very, very tiny. So, I mean, I think you can hold both views, right? You can say, yes, mass incarceration, overcriminalization is a real and present and serious problem, and it needs to be addressed. And you can also say that almost complete lack of prosecution of sexual assault and rape is a real problem that needs to be addressed. So, absent a kind of we're just getting rid of criminal law altogether approach, I think that you can both be in favor of addressing and dismantling mass incarceration, and you can still be in favor of having a role for the criminal law in addressing sexual assault.
So I guess this is a confession that may just betray my advanced age, but I will confess that I'm not an abolitionist. I don't see the plausibility of a world where there is no functioning criminal law. And I don't think there's a universe where you can hold people accountable for certain kinds of crimes, including certain kinds of sexual assaults, and not have some kind of a criminal justice system. So to me, those two things are in tension, but I also do worry about who ends up getting swept up and who ends up getting punished disproportionately. And this is just true across the board of almost any crime that you could possibly think of, from drug possession to murder. And if you just look at the statistics, overwhelmingly, it tends to be younger men who are of color, generally Black men, and the statistics for people who have been wrongfully convicted of sexually assault are staggeringly Black men if you go to the National Registry of Exoneration. So that piece of it does concern me, although I agree that when we talk about these cases, sort of in the overall heap of criminal cases, they're a tiny, tiny, tiny fraction for the reason that Michelle pointed out. You asked about students, and this part to me has been so interesting. And I'll just say this sort of one anecdote, which is that one of the clinics that I run at the University of San Francisco focuses on racial justice issues kind of writ broadly. And in 2018, a colleague of mine in the legal community came to me because he was referred a case of a young Black student at a university that was like 98% white, or at least not Black, who had been accused of sexual assault. And this person couldn't take the case because the person who was accused didn't have any money. This was a Title IX case, not a criminal case at that point. And, I was inclined to say no to this because I didn't have any experience litigating Title IX cases. That wasn't what we were doing. We had a lot on our plate anyway, but I went back to talk about it with my students in the racial justice clinic, who at the time were all women and mostly women of color. And it was very interesting. They felt really strongly that we should take it. And so they said, well, he has nobody else. If we really believe in racial justice, then we take the really hard cases. This is a hard case. We need to do this. And so we ended up taking that case, and we've taken others since then. So I find it really fascinating. I teach in a majority women law school, and I'm sort of, it's interesting to me how due process focused so many of my students are. And I think in large part, it's because of the communities that they come from and the harms that they have experienced. And also that there's just a huge overlap in the Venn diagram between people who are victims and people who are offenders. And oftentimes you find people who have committed harms to have been victims themselves or experienced it in a pretty close way with a family member.
Can I just jump in on this just for a little bit too? I mean, I think as we talk about the racial justice lens of this, the other thing that we have to be mindful of, we talk about the demographics of those who are the accused, but when you talk about the experiences of survivors of color, who are and how they are treated in the justice system, when you talk about those who come from the LGBTQ or the trans community in particular, and how they've been treated by the system, and how their victimization is treated as opposed to more broadly. And so, I do think it's important when we are having these conversations that it is, yes, we look at the overrepresentation of particularly Black men in the justice system. I also want to lift the erasure of what feels like, survivors of color from these narratives. I think one of the biggest frustrations for me around the Me Too movement was that it felt very homogenous. It felt very gratuitous to, survivors of color. I remember watching the Oscars, and it's like, oh, I bought, the woman who cleans our buildings with me. And I was mortified by that, and recognizing that there was a whole fund that they were putting together so that we could ensure that there was representation for survivors in cases that weren't involving Harvey Weinstein. But the gratuitous nature of that, and all the performative nature of that, recognizing that when we are talking about, the experience of survivors, all survivors matter. However, those who have a least amount of trust in the system, to Lara's point, who live in impacted communities, who've seen the justice system inflict harm, and then see that they are not treated with the same level of respect or dignity. They are somehow assumed to have participated in their own harm. It makes it even more difficult. And so when we know that the number of reportings of sexual assaults are minusculely low to their occurrence, and then we see who's reporting, and then we see whose charges are approved versus whose aren't, we see victims, survivors of color, getting the short shrift. And so I just want to make sure that as we have this conversation, I do think that emphasis, to Lara's point, on procedural justice, due process, it means a lot to these impacted communities and for survivors who themselves are oftentimes eaten up in this system because they are not seen to be able to be hurt in the same way as broader, whiter victims.
So I'm glad that the role of race and gender and its intersection has come up already in this discussion about sexual assault cases. And of course, we can't ignore both sides of the conversation that we've already seen happen. The history in the United States of Black boys and Black men being wrongly accused of sex crimes against white women, right? That is a history that we live with. And then also the fact that many Black girls and Black women and trans girls and trans women's victimization has not been taken seriously. So both are there. And so maybe I can ask you, Kim, how do you think our culture and our legal system can address these inequalities and disparities? Because I think that it's good that we have been more comfortable talking about these inequalities, and they've come further into the light as people have been more aware of them. But what do you think we can do, and especially with someone in a position such as yours, to address these kinds of inequalities and disparities on both sides of the coin?
Yeah, I mean, look, I'll start with my side of the coin, right? From an education standpoint, I think a lot of people talk about DEI, diversity, equity, inclusion a lot, but man, it has to be embedded in all things that we do, that people can't even see how indoctrinated that we've become around looking at these issues, that you don't even recognize the role that race or gender or sexual orientation has in it, right? If someone is involved in the sex trade, they can be raped, they can be sexually assaulted, right? They're the assumptions that we bring to the table with that. If you see, for example, we see this a lot with Black trans women who may be engaged in behaviors that people don't understand or are appalled by. And the instinct is to somehow believe that they are not capable of being a victim. We've seen this play out in, a high profile case here in New York that was just rendered verdict in R. Kelly, and listening to how people talked about the women, the girls, again, willing participants when in really the adultification of Black girls. That doesn't happen in a vacuum, right? The culture that allows for people to somehow suggest that, Aaliyah was complicit in her own, rape, doesn't happen by accident. And so I think for us, it is really being intentional around how we train, how we look at these issues, not being afraid to talk about the intersection of race, gender, sexuality, and our work, and being intentional about having, diversity in the people who do that work. We have a specialized unit within our office that looks at these sex crimes, that looks at reviewing them for felonies. We work with a multidisciplinary team, all of those things that are intentional about the act itself, but really having to dive deeper into these greater institutional issues around race and gender.
So I want to move, there's so much more we could say about this topic, but I wanted to move a bit onto a topic that I know that some of the younger members of the audience would certainly be at the top of their minds, which is the question of affirmative consent and legislation that may introduce definitions of consent that are not the traditional definitions, let's say, that are kind of, moving in the direction of definitions like freely given, knowledgeable, informed consent, sometimes, active, sometimes words, at least in the Title IX and the university context, we have adjectives like enthusiastic, agreement. I just want to get your thoughts on these kinds of definitions that may be legislatively introduced and adopted, and right now are common in universities for the purposes of bringing disciplinary cases that may end up with expulsion, say, and moving that across into the civil and criminal contexts. So I just thought I would get let's start with Michelle.
Thank you. So I think it's important to think about these recent legislative transformations toward affirmative consent in the historical context, right? So at common law, there was, and for a long time, there was a requirement that not only that there be a use of force, but that the victim resist to the utmost, right? So had to physically fight off one's attacker, to the point of risking one's life. And so then there was a transition to primarily just conceptualizing rape in terms of forcible intercourse without consent. So both physical force and non-consent were required. And then we saw a shift more toward, in like the 80s, 90s, toward non-consent-based statutes, which exist in most jurisdictions now. There is at least some crime, be it the most serious or a lesser offense, which is defined in terms of sex without consent, but under a no means no model. Okay, again, sort of requiring the victim to verbally resist, no longer physically resisting, but sort of working on the assumption that there must be some resistance by the victim. And this can be incredibly problematic, especially in cases where the victim is intoxicated or otherwise incompetent in some way, the cases where a victim is sleeping, or very many cases where the victim sort of goes into a state of tonic immobility because of fear and panic around what is happening. So moving toward an affirmative consent model, there are at least 13 states right now that have moved toward an affirmative consent model. They all use sort of variations, freely and affirmatively given permission or freely and affirmatively given agreement. And some of them speak expressly in terms of whether words or conduct or both are required. Others speak to a need for knowing consent. And so, I think that sort of move not only kind of tracks a move in social norms that we're seeing, but I think there's much to commend it in the sense that it doesn't seem right that the law should be looking to the victim and expecting the victim to resist in some way, right? That approach strikes me as a relic of the past. And even when it's only verbal resistance, it seems that the better way to go, I would suggest, is to make this move toward affirmative consent.
Lara, maybe we could hear from you on this, and also Kim, these kinds of legislative measures around consent and changing the definitions of consent more in the direction that Michelle is talking about, will they help the adjudication of sexual assault cases in the justice system? Or are there any versions of this that could complicate or hurt the protections that, say, the accused have, or even the victim in the justice system?
So I want to, I think, present probably the opposite argument about affirmative consent. And I think, Jeannie, you and I respectively have been a bit in the thick of it through the work that we do for the American Bar Association and the ALI, both of which recently had extremely heated debates about whether to change the model standards. And both the ABA and the ALI, as of course you know, rejected affirmative consent. They rejected the affirmative consent model that has been adopted in New York, and as Michelle said, other states. And the reason why, and this is a lot of people who are extremely thoughtful about this issue from all sides, and both of these organizations, was a concern about eroding defense protections, and in particular, burden shifting, and sort of presuming guilt on behalf of a defendant and moving the burden onto them to sort of disprove consent. And so what the ALI ended up doing and the ABA ended up doing something a bit rather similar was coming down on the side that consent is something that, at least in the courtroom, at the legal standard, can be expressed, it can also be inferred from behavior, both action and inaction, in the context of all of the circumstances. And going to this point about, there should never be a requirement of a verbal or a physical resistance. And that was a relic of the past. And it was deeply problematic, saying that if you didn't fight back, you couldn't be a victim, or if you didn't scream no, you couldn't be a victim. But at the same time, there's a willingness to be more, I think, expansive in considering behavior that can be considered consent under, again, all of the facts and circumstances, rather than requiring some kind of enthusiastic affirmative act by the person bringing the accusation. And then I would just say that the AELI and the ABA also came down, of course, on the side that consent can be withdrawn or revoked at any time, which I think is also something that's an important reform on our path to making these adjudications more fair without landing on the side of affirmative consent.
So can I just jump in quickly on the issue of burden shifting? I mean, I fear that that's sort of a confusing way of framing the issue, right? At all times, there's the presumption of innocence. There's a burden on the prosecution to prove every element of the crime beyond a reasonable doubt. Whether we move to an affirmative consent model or to a contextual consent model, as the ALI did, does not change the burden, right? It is always the state's burden to prove every element beyond a reasonable doubt. The only question then becomes, what are the elements, right? What are we looking for? Are we looking for a no, some sort of verbal resistance? Or are we looking for either words or actions that indicate yes? Or are we sort of settling somewhere in the middle, as Lara explained, with the kind of hybrid contextual consent approach that the ALI adopted?
Thank you for that, Michelle, because that's what I was going to say. And I deal with the laws as they exist now, and our role in executing on those. And we have seen that shift in consent, and I think some areas that seem more obvious than others. For example, people in police custody aren't consenting to, being sexually abused or assaulted. And so we're slowly but surely catching up. But I think the concerns that you raised at the beginning of the question, to Michelle's point, the burden still sits with us. Lara's point of, who your burden is to prove this beyond a reasonable doubt, the onus should not be on the defense to say, no, not me. That is the tension that we deal with as the laws are set up now. I think, for us recognizing, again, the history that we have, particularly in how we viewed one's ability to say no, has evolved. And as we look, for example, here in Illinois, under instances of duress that maybe you had not contemplated before, we had a case not too long ago where we had a lawyer who was, using the threat of duress for one of his clients to get her to perform sex acts on him. And, years ago, you'd be like, well, can you? What does that look like? We still have to prove it all up. But the absence of even the recognition that that is one of the ways in which an assault can occur, I think misses the mark of how we've traditionally defined instances of assault or abuse. And that evolution, I think the heated debates and conversations within the ABA and the ALI recognize that we don't want a pendulum to swing so far that we are disregarding, the rights of the accused. But also, I think we're in this place where we have been so dismissive of, these acts as they've occurred to survivors, that overcorrection is we should be watching out for. But it is because we've gotten from a place where we have just wholeheartedly dismissed these types of abuses against survivors for so long.
So another really important question in this moment of reform is the question of statute of limitations. And so many survivors, as we've talked about already, as Kim mentioned, and Lara, are not ready to step forward immediately, and it may even take years after an event, after an assault, for them to feel ready to step forward and enter the process of the justice system. So what are the considerations of having a strict statute of limitations when you're talking about rape and rape kits, versus having a more expansive idea about statute of limitations? Michelle, why don't we start with you?
So that's, thanks for raising this question. I think it is important. And I think it's another place we're seeing significant shifts in the states. Historically, there have not been statutes of limitations for the most serious crime, murder, right? So it's not unprecedented that we would have some crimes which are taken so seriously that we say, you know, we're not going to reward you for hiding the body well and running the clock out. And so some states are now saying, we're not going to let people off the hook on rape either. So if you manage to keep your victim quiet or just get lucky enough that you don't get accused, or at the time there's not enough evidence, we're going to be able to come back and prosecute you anyway. And I believe I did a quick look, and I think there's at least 8 states that now have no statute of limitations for at least their most serious sexual assault. And yet others do, right? So I believe New Hampshire still has a 6-year statute of limitations. So that's quite short, particularly given what we know about the difficulty of survivors coming forward. I think the Catholic Church's sex abuse scandal has done a lot to educate the world, unfortunately, about how difficult it can be for children to come forward. And it's difficult for survivors to come forward across the board. So I think moving either toward longer statutes of limitations, or perhaps even abolishing them, as some jurisdictions have done with respect to the most serious offenses, seems to be the direction in which the criminal justice reform is going. There's a whole other set of debates that we won't get into, I don't suppose, about civil statutes of limitations, but at least with respect to the criminal law, sort of treating the most serious version of rape or sexual assault in a jurisdiction equivalent to murder and saying, we're just not going to have a statute of limitations for this kind of crime, seems to be the direction it's going. And it strikes me as helpful, especially in cases where victims have a particularly difficult time coming forward.
Laura?
I think that Michelle's invocation of the horrible abuses of the Catholic Church are a powerful, powerful example of why statute of limitations are extremely problematic. And I guess you have to ask the question, what is the purpose of a statute of limitations? Why do we have them? Michelle is saying essentially, look, if it's a very, very serious crime, like a murder, we never have them. At least I can't think of a state that puts a statute of limitations on murder. And so if you're talking about extremely serious assaults on children who for many, many reasons are not going to be able to come forward, if you're talking about a class of crimes that are so violent and horrific and involve that kind of a violation, I think it's hard to come up with an argument for why you would have a hard statute of limitations. And I guess just for going to Michelle's point, there's also to me a concern about inconsistency, which is to say, you could live in a state where there's no statute of limitations. You could live in a state where there's a 5-year statute of limitations. And then it's literally about like which side of the river you're on, about whether or not your case could be prosecuted. I realize that's true of many crimes, but in this particular case, it seems particularly problematic to me.
Okay, so all right, we are soon going to turn to questions from participants of the webinar, but I'm going to close my questions with the following. I see a lot of students these days who are very much interested in the criminal justice reform movement, and I hear some of them saying, "I'm not sure that sexual assault really belongs." Or at least it's not the best place. The criminal justice system is not necessarily the best place to resolve all sexual assault cases. And so I wanted to ask each of you to address what you think about that, what you think about alternatives, what have you seen about experiences outside of the criminal justice system, and particularly for Kim, State's Attorney Foxx, as a prosecutor who is active in the criminal justice reform movement. How do you grapple with this question of sexual assault and the goal of moving away from a carceral system, and whether sexual assault is best addressed in that criminal context? I'm sure the answer is it depends, but I would love to get your elaborations, all of you.
Well, let me start as a survivor. And I think it's critically important. I've actually had a really difficult couple of weeks in a moment of full transparency. My abuser, my childhood abuser, passed away a couple of weeks ago. And the abuse that I suffered at his hands was some 40 some odd years ago. And I can tell you that in the wake of his death, it felt like it happened in an hour before. And so I say that, one, in that, we never pursued the case in court. It was a family member, but this sense of justice, this sense of whatever this wholeness that we believe in the system will make survivors. I, as a survivor, can tell you that we do not have the ability to do that. That's just me having worn the hat of a survivor, the hat of a prosecutor, and the hat of a reformist. I don't have this belief that we are superheroes that believe that the system is going to make people who have suffered these horrific abuses whole. What I do think, though, is that we start there, right? We start with telling the truth, that the system, the way it is currently designed, are we talking about accountability? Are we talking about wholeness? Like, what's the goal here? And if the goal is accountability, is there ways to do it outside of the system where you are held accountable for your actions, but also able to move on? I did a lot of work in the juvenile justice space. My abuser was a juvenile when he started. We have these sex offender registries here in Illinois where people can petition to get off. I can see that. They come to me directly, that we can be able to say, like, has this person grown from this behavior? What are the unique circumstances? Where were you? And how do we get you into account, but also allow you to have your life for the rest of your life? Those types of things where I think we saw a pendulum, and we were putting kids on sex offender registries for the rest of their lives, and they were being marred. And we know that the data, the research, the evidence tells us that many of them outgrow that behavior. And even with that intellectual nuance that I have, I know that a 15-year-old abuser, their survivor, is still going to hurt. And so it's not as simple, it depends. And I apologize for going a little super personal with it. It's the recognition for me in this role that we have to stop assuming that the structures that we have put in place to address these issues, whether my abuser had gotten 40 years to life, he's not here and I still hurt. And so I think we have to, as we talk about being survivor-centered, be honest about the limitations of what we have, be creative, and ultimately say what I think most survivors say is that they don't want somebody to do this to someone else. And then how do we work on that? And that means not just being survivor-centered, but making sure that the person who's caused the harm is able to grow from the harm that they've caused. And it's messy. It's not simple. And as we try to correct for the historical failures of the system to do that, I think that should be at the focus, is that this system wasn't built to get people whole.
Amazing. Yeah. Lara, Michelle?
I mean, that's just, it's hard to follow because it's very, very powerful. What Kim said, I think I'm going to answer the question with my academic hat on rather than my defense attorney hat on, and say that I think the most important thing probably for survivors is to try as best as we can to give them some sense of power and control back. And so what I mean by that is it sort of seemed like in earlier times, the options were, if we end up moving forward with your case, you have one option, which is that you can go through the adjudicatory system. And as Michelle and Kim pointed out, that was even highly unlikely because most people never even got to that place. And not everybody wants that. Some victims do. Some victims do want to go through the adjudicatory process. They do want the courtroom, but not everybody does. And so to say to someone, as many do now, well, you can have the adjudicatory process or you can have nothing, is disempowering for people who aren't served by that. And so I think it's important to think about, as Kim said, ways that we can be creative in thinking outside the box for those subset of victims. And that is where I think approaches like restorative justice are important to talk about and bring to the forefront. And I say that knowing that it is controversial, and there are people who believe in restorative justice for other types of crimes, but really feel that it's not suited to any kind of sexual assault, sexual offense kind of a crime. And so I understand that there is absolutely a line of thinking that really thinks that it's just a poor fit. I would push back against that and say that I think that there are cases where it is appropriate and it can address harm and accountability, because I think there's a lot of misunderstandings about what restorative justice is and what it promises and what it can deliver. It does seem to me that for people who choose that option because they don't want the adjudicatory system, and again, I think it's really not about forcing people into one or the other, it's about giving them a choice. For those people, I think the satisfaction rates are higher, but I also think that the recidivism rates, at least as it has been studied in other countries where RJ is more accepted, are lower. And so it's an alternative that I think is worth taking into account, or at least offering. So I just go back to the idea that I think empowerment and choice is important.
And I'll just jump in to add to that. I mean, I think we're in agreement on many main points. I guess my concern is insofar as survivors choose something other than the criminal justice system, I'd like to make sure it's because the criminal justice system is doing its job properly, it's treating them with respect, it's doing trauma-informed, victim-centered investigations, and they are not being re-traumatized and re-abused through this process, right? At the moment, given how broken the system is and the utter unlikelihood of anything positive coming out of it, of course people would prefer, many people would prefer something other than the criminal justice system. That's for many reasons, but a big part of it is because our criminal justice system is so broken when it comes to these sorts of offenses. So just with that sort of caveat, I would say in an ideal world where we handled these cases better, I do agree that there's still a place for what I would call alternative sites of public accountability. That could be either restorative justice, it could be Title IX in a university college setting, it could be Title VII, employment discrimination, sexual harassment in a workplace setting. It could be a tort case. Illinois has a Gender Violence Act and some other jurisdictions as well. So, either a traditional common law tort or one of these newer statutes that specifically address these sorts of offenses. It could be going on Twitter and having some kind of public accountability, right? But people need to have different ways in which they can speak their truth and hold their perpetrator accountable. Some come with additional problems and difficulties. And I think the broader range of options we have for survivors, the better off we are, because no, not every case either needs to wind up in the criminal justice system, nor even under ideal circumstances would all survivors want it to wind up in the criminal justice system. So I think it's important to do both and, right? Fix the criminal justice system and build up robust alternative sites for public accountability.
So we, with everyone's permission here, it would be good if we could go to 3:10 to get in a few questions from the audience, if that's okay with the panelists. So one really excellent question that has come up in the Q&A from an audience member is something that follows up, Michelle, on the whole idea of trauma-informed practices in the prosecution of these kinds of cases. And I take it from your comments that you are in support of trauma-informed practices. And of course, we have to get into the definition of what that might be, and there may be disagreement about what that means. But Lara, I also wanted to get your take. I know that you have written in the past, at least in a few contexts that I have seen, that have seemed skeptical of trauma-informed practices when it comes to either prosecution or maybe even in the Title IX context, where universities are now increasingly thinking of their processes for discipline as being trauma-informed or survivor-centered. And I don't know if those two things are being used simultaneously as interchangeably or as different things. I wonder, Lara, if you had some experience and thoughts on trauma-informed practices.
So it's a loaded term and it means so many different things depending on the context, to which I'm going to defer to Michelle because she's really the expert in kind of defining all the gradations of the term. So I can just speak to the concern that I have, that I worry that in certain contexts it's over elasticized or over relied upon. So just to give you an example, in the Title IX context, which is where the students and I do a fair amount of work these days, what concerns me is, for example, an adjudicatory system that's set up to have one person be the investigator, the detective, the prosecutor, the judge, and the jury. So that was the system until 2018 for all of the California state universities and most of the UCs in California. So we're talking about like 250,000 students were under that single investigator model. And what would often happen is that the single investigator would employ some version of a trauma-informed approach. And so they would basically interview both parties and not really do any sort of due diligence in terms of looking for evidence from either side that might corroborate or undermine what the other side was saying, and instead just simply say, using the trauma-informed approach, I'm going to essentially believe the person bringing the accusation. And that to me was problematic because it did away with the whole idea that the system is designed to test allegations, and that a bare allegation alone plus an approach that says you need to believe a bare allegation equals a finding of responsibility, potentially suspension and expulsion. And so what we've seen on our end, and again, I'm talking about Title IX, I'm not talking about the courtroom, is that approach essentially supplanting an investigation. And that, to me, as a defense lawyer, as someone who believes in due process, particularly when the consequences, are extremely outsized, and really we're talking about the end of somebody's education, is concerning.
So,
So
Michelle,
I could just jump in briefly. So
yes.
I think Lara is entirely correct to say that the phrase trauma-informed is used in a lot of different ways. I think there are people who are very concerned about due process, and it's another set of debates about what level and structure of process is due in a Title IX setting versus a criminal setting. So that's sort of a different kettle of fish. But the basics of a trauma-informed approach are some of the things we started talking about at the beginning, right? Start by believing the victim. Do the investigation, right? The idea is to do the investigation while being informed about things like the effect of trauma on encoding of memories, right? The effect of trauma on one's brain, and if a survivor is saying one thing at one time and then says something slightly different at another time, an uninformed investigator would think, oh, that's an inconsistency, she must be lying, I'm going to stop looking into it. Whereas an investigator who's been trained on the effects of trauma on memory formation would recognize that that's not unusual, and that trauma does things to our brains that can lead to inconsistencies, can still be perfectly consistent with the fact that this person's telling the truth, and then all the while continue your investigation, right? So, I mean, I certainly wouldn't hold up a trauma-informed approach as an excuse to not do proper investigations or to deny proper process. I think that's a misuse of the term.
Mm-hmm. Okay, so we have one question from a member of the audience who wants to ask about sex offender registries and whether they do address the needs and desires of survivors, and in what way, and do you believe the registry impacts the rates of sexual assault or fighting sexual assault or addressing sexual assault?
Okay, I'll jump in. As I said in an earlier answer, the use of the expansion of the sex abuse or sex offender registry, for example, to juveniles, when there was a body of research that said that particularly for younger offenders, when you have interventions, the likelihood of recidivism amongst this group is low. And so the question that one would have to ask is, what is the purpose then of the registry, other than to identify who these folks are and to be able to keep tabs? And but if the tab is for the purpose of ensuring that no other harm is coming, and for this, at least this population of folks, we know that they are less likely to do that. What are we doing? And I think, again, as we talk about an examination of our criminal justice system, these registries and the promise that they held that was held out to survivors and to communities was that this was somehow going to keep us safer. And we haven't seen that come into play. What I've seen a lot in terms of people who come back into the system who have failed to register, and we see a lot of arrests that are related to that. We see a homeless population, we see an impoverished population, we see, the limitations on one's ability to get stable housing. I see more the failure to register from folks coming in because of those circumstances than those same people going out and reoffending. And so I think, the promise of these registries to keep to reduce sexual assault because it serves as a deterrent has not been seen.
Yeah.
So go ahead.
I was just going to thank State's Attorney Foxx for those comments. And I mean, I think however well-intentioned they might have been at one time, they have proven a colossal failure and a source of inequality. And the American Law Institute recently had a debate about whether to recommend that sex offender registries simply be abolished. And I was in favor of that approach. And they've proposed instead what they put forth as a better version of a sex offender registry. So I would certainly, if there are any legislators out there listening, I would, if you don't have the political will to abolish it in your jurisdiction, at least looking at the new model penal codes approach might go some way toward improving it.
So can we talk about a situation that may be common about when there's a case and then a victim who is or becomes reluctant to proceed, does not want to be part of the case at some point, and the difficulty of balancing the considerations about whether to go forward and with a criminal case, and how do you think about that? Is it, I would think at some point some prosecutors would have thought, well, we have no case, then there's no prosecution. And I wonder, I was also a prosecutor in the Manhattan DA's office, and I remember in gender-based crimes, we did have a mandatory policy that you would go forward in cases even when the victim did not want to go forward. And that was something that was very strictly enforced for the line prosecutors in that office. So I just thought I would get your thoughts, especially Kim, about that situation.
No, I mean, no, we don't have such a policy in our office. We recognize as we started this panel that there is the crime that they've had to endure, and as Lara pointed out, the trauma that is the justice system. And again, we have to ask ourselves, what is the ultimate goal? If we want to, if it is providing accountability for the person who caused the harm, is it wholeness for the victim? What is it? If we are going to inflict more harm because we have someone who says, listen, I can't do this, the arm of the state then forcing you to continue on somehow doesn't feel just to me. And so I think the approach that we take is, having our specialists work with our survivors to address whatever the issues and concerns may be, because people's reasons for not wanting to pursue very, very differently. It depends on the relationship between, the victim and the defendant. Perhaps it's a family member, and what are the ramifications for the family? Perhaps it is a spouse, perhaps it is, the nuances are so great and the implications are so specific that to me, to have a strict policy of proceed anyway is dismissive, again, of the complexity of what this is. And so it's not simply to say, and that doesn't mean that I would say that if a survivor said, I don't want to go forward, that there aren't ways that perhaps we could pursue it without it. It's a multiple survivor case, as we've seen in from time to time, that we can do it without that particular person. Perhaps we would, but it is specific to the case, but we don't have a blanket policy that says, once we file it, you're in it. That is not trauma informed.
Well, this has been a truly outstanding panel discussion, and I'm very honored to have been a part of it. Thank you so very much for your participation, your contributions, and thank you to the audience for having joined us for this hour.
Thank you so much.
Thank you.
Thank you.